Today, we will be dealing with the important issue of employment injury, examining the very complex Workmen's Compensation Act and the proposed Employee Compensation Bill. Employers are required by law to insure against liability for injury or disease to their employees arising out of their employment. As an employer, you are responsible for the health and safety of your employees while they are at work. Your employee may be injured at work, or they or a former employee may become ill as a result of their work while in your employment. They might try to claim compensation from you if they believe you are responsible. The Workmen's Compensation Act requires that you have a minimum level of insurance cover against any such claims. In this regard, it's important to understand when the relevant provisions of the Workmen's Compensation Act would become effective. There are three situations to note here. 1. When an injury disables a worker for at least 3 days. 2. When a report from a medical practitioner indicates that a worker's injury resulted in a permanent partial disability percentage. And 3. When a claim is made within 6 months from the date of the accident. Determining compensation for injury can be challenging. Compensation during injury leave, once the injury period exceeds 3 days, is usually payable at 2/3 the average monthly wage for the period of injury. For permanent partial disability, a lump sum is paid, calculated at the percentage disability assessed by 4 years average annual earnings. And in the event of death, the amount payable is 3 times average annual wages. Employers must also understand that workmen's compensation matters may be dealt with in the High Court. Some of the situations in which this would happen are as follows. When a workman is entitled to compensation and agrees to the extent of injuries and to accept a lump sum payment pursuant to the Act. Where a workman is entitled to compensation, but there is disagreement on the extent of injuries suffered, and an application is made to appoint a medical referee. Where either the workman or the employer wishes to review payments. And finally, where a workman is deceased and leaves behind dependents. Let us now take a look at the proposed Employee Compensation Bill. While the new bill tries to improve on the Workmen's Compensation Act, we are concerned with some of its provisions. For instance, the new bill broadens the definition of employee and attempts to provide universal coverage to include all categories of persons coming into an organization, and provides for the establishment of an employee compensation board. However, no provisions are made for representing employers' interests on that board. Under the new bill, employers are penalized by finding them liable in situations where the injury is solely the result of serious and willful misconduct of the employee when it results in death and serious disablement. Why should an employer, after doing everything he could reasonably do to provide a safe working environment and equipment for employees, and the employee refuses to adhere to safety instructions, be held liable for compensation in such circumstances? Where an employee is found dead at the workplace, it is presumed that death came about by accident arising out of and during the course of employment. An employer, therefore, is presumed liable unless he can prove otherwise. The new bill requires employers pay reasonable expenses incurred in respect of medical-related treatment, hospital care, rehabilitative treatment, domestic attendance, modifications to home, and travel expenses. There seems, therefore, to be no limit on the amount of costs which can be incurred and which an employer may be liable. We at the ECA would like to see employee injury compensation improved for the benefit of claimants and employers. We would like to see the claims process faster, legal fees reduced, and rehabilitation more readily available. For employers, the key is to ensure that you do all within your control to prevent employment injury. However, if injury does occur, you must ensure that you are informed by personnel or advisors like the ECA so that your claims are dealt with properly.